Good afternoon, and welcome to the Quarles and Brady Business Law Training Session titled, What Every Lawyer Should Know About Political Law Compliance. I'm Kim Mahan, an attorney here in the Business Law Group in Chicago. Before we begin today's presentation, we would like to invite you to join us on April 11th for next month's program on the Me Too movement. As always, we have a few housekeeping items to review. For CLE credit, for our in-person guests, please fill out the CLE sign-in sheet located at the registration table before you leave today. For our webinar guests, please email the CLE form located at the back of the PDF materials to Megan Blythe, whose contact information is on the form. If you are listening via webinar and have a question, please type your question into the question box on the upper right side of the screen and press send. The conference host will make sure the speaker receives the message. Also, for our webinar participants, we have muted all phone lines and participants are in a listen-only mode. A survey will be emailed to you after the program. Please be aware that this presentation is being recorded. And now I would like to introduce today's speakers. Addie Olson advises corporations on lobbying, campaign finance, ethics, and pay-to-play compliance at the federal level and in all 50 states. Her experience includes representing corporations with government affairs compliance issues, developing and implementing comprehensive corporate government affairs compliance programs, overall corporate governmental affairs policy and practice assessments, and lobbying and ethics-specific audits. Jen Jackson focuses on assisting corporations on lobbying, campaign finance, and ethics at the federal level and in all 50 states. Some of her experience includes representing corporations with government affairs and political law compliance issues at the federal, state, and local level for matters including registration and reporting, campaign finance registration, reporting and contribution compliance, internal audits and assessments, and enforcement actions. And now I'll turn it over to Addie.
Thank you, Kim. So today, I want to thank you guys for being here, and I'm just going to go over a little bit about kind of what we're going to do today, and then I'm going to turn it over to Jen. So today we're going to do four things, basically. We're going to learn to spot some compliance issues in the political law area. We're going to break down those issues into some core questions. We'll talk about developing tools that can address the challenges that you and your company might face related to political law. And then if we have time, we're going to review some recent changes in the law. So political law compliance is an ever-changing area. It very much is a pendulum that swings related to scandals in states or the feeling related to ethics in particular communities. So it's a very reactive area of law. So everything we talk about today, I just want to let you know that we're talking about a point in time and that things are changing as we speak. So there's a lot to be said about lobbying and campaign finance, and we're going to do our best to fit that within the hour today. We'll address lobbying registration, gifts and ethics, which is critical, and I'll try to spend some time in campaign finance on the oft misunderstood Citizens United decision. And I guess part of this is just explaining why this is relevant and how large of an area this is. There were $3.7 billion spent last year on the 2018 elections, much of that corporate dollars, and that doesn't come without regulation. So we're going to delve into that a little bit more too. And to frame the context of lobbying that Jen will go into, there are about 12,000 lobbyists registered in the United States. So this is something that most companies, if you're not involved in political law, it at least touches your industry. So what we're going to go through these major areas is lobbying registration and reporting, and ethics and gift regulation. For those two sections, I'm going to pass it over to Jen. And then I'm going to go over campaign finance and some pay to play at the state level, and then talk about enforcement and solutions. So with that, I'm going to turn it over to Jen to start talking about lobbying.
right. Yep. Okay. Thank you to Addie and Ken. So we'll jump right into lobbying. At its base, the definition of lobbying is communicating with the intent to influence. But for most corporations and employees, the complexity and the confusion comes into the nuanced way in which lobbying is defined within a specific location. And then on the broader level, that definition changes from place to place, either state to state or within cities, within a state. It can just get confusing. So when a corporation is considering communicating with officials, when we have clients that come to us with that question, what we typically do with them is run through a specific set of questions to figure out if they land within the definition of lobbying and then if registration will be required. So initially we ask what the intent is of their communication. Do they have a specific ask of an official? Are they there to discuss legislation, administrative action? Are they there to educate on something specific? If they're a pharmaceutical company, are they there to educate about a specific disease, something along those lines? Or are they there to discuss procurement with the government agencies that may be in question? Who is their audience? Obviously legislators, agency officials. Is it someone further down the line at an agency? Staff members. The method, obviously direct communication is in person, telephone, email, that kind of thing. Indirect lobbying is either, communicating, for example, with an employee further down the chain and helping them to kind of turn around and go talk with the official that you need to really get to. Grassroots efforts would be considered indirect, or you're working through a trade association. The time question really comes down to how much time and therefore how much compensation is being paid for the lobbying effort, which we'll talk about later, may trigger registration. And then are there any expenditures being made? For the most part, that means expenditures on behalf of officials, or taking Senator Smith out to dinner. But some states also include expenditures for a lobbyist, travel and lodging, things like that, which is something to watch out for. And then once we go through all that, we look at the specific law, and then we go look at the exceptions, because there are often exceptions that can also practically swallow the rule in terms of whether registration is required. It's a bit of a process, but we'll get through it. So examples for lobbying registration in Illinois, they require registration prior to direct communication with officials. The state defines communication to include expenditures on behalf of an official. So again, if you weren't really expecting to have this conversation with Senator Smith but end up taking him out to dinner, we're going to have to get you registered right away. An example of a time and compensation threshold in California, in-house employees working for a corporation may have to register if a third of their time in any calendar month is spent in direct communication, which is a fairly high threshold. It would be a lot, when you consider just direct communication, that's a lot of time for an in-house employee in a month. For outside consultants, if the corporation hires outside lobbyists, they're going to need to register if they get paid $2,000 or more in any calendar month. And then compensation and expenditure example would be in New York. They have sort of a $5,000 threshold that includes compensation and expenditures for lobbying, any lobbying related expenditures. So it seems like a fairly high level, but it can be chewed up pretty quickly there in New York. For reporting, so you've now discovered that you need to register. I keep hitting the microphone. You discovered you need to register, you're actively registered, and now you have to worry about what you need to report. There's 4 major considerations when you're thinking about lobbying reporting. Who has to file? How often do you have to file? What do you need to disclose? And what are the record-keeping requirements? So the filer can be the principal or the employer, which is the corporation in this situation. If they have an in-house employee who's registered, that lobbyist may need to report. An outside consultant lobbyist or the firm may need to report, or any combination of the above. Some states require everyone to go ahead and submit a report. Some states have to, only the employers for only the lobbyists. So for example, in Wisconsin, the principals file semi-annual reports. Things that include all of their lobbying related expenditures. In-house lobbyists and outside consultants will report their time on a daily basis for 6 months in terms of lobbying, and then all of that is incorporated in terms of compensation into the entity report. In Illinois, the principal files every 2 weeks, and they file expenditures on behalf of officials, but then a lobbyist will go in twice a year and say, yep, that expenditure was made by me or on my behalf for this client, and that this is accurate or not. In Texas, a principal that is required to register and report may not have to if the lobbyist captures all of that company's time on their report. And lobbyists in Texas, if they spend less than $1,000, can report annually. If they go over that amount, they can report monthly. Massachusetts, all lobbyists and all clients report twice a year and report everything. And Pennsylvania, principals are quarterly, and lobbyists don't have to file, again, if the principals capture their expenditures. So here's a little quiz for you. How many lobbying reports are due each year? Which will not come as a surprise, but it's the biggest number up there, 452. And that's maybe more at this point. It's a slightly old number. But the upshot here is just a reminder that, particularly if you're involved in more than one jurisdiction in lobbying, there could be a lot of due dates and requirements for reporting that you need to keep on top of. It can snowball pretty quickly. The calendar becomes very important. That takes us into frequency. Again, it varies. I think I'm going to say it varies a lot during the presentation. Again, in Illinois, we talked about you report every 2 weeks. Some states quarterly, some states only once a year. It's sort of a rule of thumb is that the more often you report, the more narrowly tailored your reporting requirements are. But once you get to the quarterly and sort of semi-annual, annual reports, they are going to require everything that you're spending on your lobbying efforts to be included in some way or another. So examples, Vermont is one of the states that that requires reporting monthly while they're in session, and then it goes to some, every 3 months after that. Washington, lobbyists file monthly, and then employers are required to file an annual report by the end of March, or the end of February. Minnesota, lobbyists are semi-annually, and then the employer report in March. Minnesota is interesting. It's just a lump sum number reported by the employer, but again, that's one of those states where everything that you do that's lobbying related, any cost goes into that big number. So it looks not too bad, but it can be a little bit intimidating. And in Florida, it's interesting, only lobbying consultants and firms, lobbying firms file compensation reports. Corporations and in-house lobbyists are not required to file reports in Florida. So disclosures, again, it varies by where you are and what's required. Some of the states with the bigger requirements can require pretty much everything up on that list. I won't read it to you because it's a lot. And then like I said, in Illinois, it's every 2 weeks, but they're only requiring that you disclose expenditures maybe on behalf of a public official. So many people file zero reports all year long in Illinois, even if it is every 2 weeks. Some of the ones that need to jump out, campaign finance contributions. Not every state, but some states require that those are disclosed on reports, both either by the lobbyist personally or by the corporation that they work for. Grassroots expenses, some states don't consider grassroots lobbying to be lobbying, others will require that either registration and or reporting for grassroots efforts. So example, Massachusetts says everything except the name of your firstborn child, which I guess it's funny if you work in my area of law, but I think anyone who's actually filed in Massachusetts will tell you it's not that far off. They want to know everything you've done. They want your cab receipts. They want to know where you started and where you went in your cab. They want to know who was with you in the cab and how much it cost. They want your flight information. They want where you went to eat and how much it cost, who was with you at dinner. And then all the overhead, the rent and everything else and compensation that goes into those numbers. I'm happy it's only twice a year. It's a lot of work in Massachusetts. In Illinois, we talked about already. Another example would be Delaware. Matters lobbied only. You either report that within 5 days of lobbying a new one or by the end of June. And then the reports are just for gifts and entertainment on behalf of officials. So moving on to record keeping, I think this is not as considered as much by people when they register, but there are a lot of good reasons to keep good records. Obviously you want accurate and timely reporting. You want to follow corporate internal policies and corporate records laws. The biggest one I think that gets people's attention the most is response to audits, either an internal audit by a company, which can be very detailed and frustrating, or state audits. Many states have a framework set up where they can go back and audit lobbyist reports. 2, 3, I think the highest I've seen is 5 years look back for a lot of these states. They can Some states will do sort of random audits every year. Connecticut, Tennessee are states I can think of off the top of my head that will randomly audit folks. Other states will audit if it's in response to a complaint or if there's a red flag on there that they see something that they'd like to have a little more information. Audits don't have to be painful, but if you don't have the records that you were, based on what you reported, it can start to get a little challenging and frustrating for folks. So to get there, clearly define responsibilities. People need to know what they need to do. So typically what we do with our lobbyists when they register, we let them know, hey, okay, so you're registered and here's what your reports are due quarterly, and here's what you're going to need to remember or write down, who you met with or how long you spent, if you made any expenditures, that kind of thing. It's good to know up front that they're going to have to do that for you. It helps to have a consistent structure for folks. It gets a little more, some more cracks can form where things can fall through if it's just your lobbyist in New York keeping track of his expenditures and your lobbyist in Texas keeping track of her expenditures. We recommend that everyone kind of comes back to a central person, either within the corporation, general counsel's office, or outside counsel. So that, for example, if you do get audited and your lobbyist in New York left 2 years ago, but he took all this receipts with him, you still have the information you need to respond as a corporation. And then training is a big one. We want to make sure, again, we already let our lobbyists know what they need, but there are folks back, support staff back at, in the corporation that need to know, this is information, just tuck it away somewhere, put it in a file, keep it safe in case we need it in the next 5 years or so. Moving on, dancing on quickly to ethics. Major considerations, so when we talk about ethics, we talk about expenditures on behalf of officials, typically. That's the big question. Can I take Senator Smith out to dinner? Is that allowed? How much can I spend? What do we need to do? So again, the major considerations are permissibility. Are there limitations on how much you can spend? Do we have to disclose that expenditure? And everyone's favorite, record keeping at the end. So permissibility. Some states have a total ban. Wisconsin is almost a total ban. We call it a no cup of coffee state. There are very, very narrow exceptions for folks in Wisconsin to buy officials anything. And it's almost completely banned for lobbyists and principals. There are often, bans in place for people doing business with the state, or if they have business in front of an agency for obvious reasons, there are states that don't want that to be influencing anyone. And they may be permitted, but not during session, or I know a lot of people's favorites are permitted without restriction. So limitations. We may be looking at a dollar amount per year, $500 total for this person per year. Dollar amount per occasion. I think in Louisiana, it's up to $63 per official per occasion, but only in limited circumstances. We talked about the session fees. There are often, but not always, exceptions and gift rules for bona fide personal friendships, family, immediate family members, or special occasions like weddings or funerals that the state will allow the expenditure on behalf of an official. Reporting. So reports may be itemized or not. That will depend on, in some states, everything's got to be itemized. For example, in Illinois, if you make an expenditure, you're going to itemize it on the report. Other states, like Texas, for example, you have to report a lump sum for your expenditures, but you only have to itemize if your expenditure on behalf of one person goes over $132.60. So remember that number. And then you have to decide or determine who's going to report that. Is it the principal, the corporation on behalf the expenditure was made, if you're attempting to influence for them? Is it the lobbyist who made the actual expenditure and was reimbursed? Does the official have to report? If they do, typically a state will require gift notices be made by the corporation to that official, either to allow them to report, or sometimes it's to allow them to pay you back so that they don't end up on one of your reports. Not every state will allow the reimbursement, but some do. Or no one reports at all. And I can't say off the top of my head that I can think of a state where no one reports that. It might be out there, you never know. Again, record keeping, especially I think in this area, it's critical, not only by your lobbyists, especially by your lobbyists, but not only, but also there are other folks out in the world who may be in your corporation who are out interacting with government officials. Salesforce is one that comes up a lot. These folks are out doing their thing without any kind of, they're not thinking about government affairs, but hey, they met with Senator Smith or someone on the local level and decided, I'll just buy you a drink or buy you dinner without thinking about are we a principal in the state? Is this allowed? Are we a lobbyist in the state? So it's important for everyone to kind of keep track of what they're doing. Ideally, a company would have, we've got clients that have sort of a pre-approval process for any gifts and entertainment that might be planned for an official. So that way the person who'd like to make the expenditure knows if they're good to go. And then there's someone further up the chain that has an idea of what's happening in that area. And then here too, because training is critical. We do a lot of trainings for folks in C-suite and again, sales folks, other folks. Our government employees are usually pretty good, or at least they know where to go to ask if they can make that expenditure. But that training for other folks in the corporate structure is so important, just to let them know that, don't whip out that corporate credit card just yet. Let's talk about what you're doing, who you're talking to, and if it's permissible where we are in the framework in which we're working. That's me, I went really fast. So I'll pass it back to Addie.
Thank you, Jen. I know that's a lot of information to take in, particularly for companies who are just looking to enter the world of political activity. We're at a place in our country where there's a lot more activity in some areas politically, and other people are pulling back out of politics, companies with different regulations. So Jen went over a lot of information that goes across different jurisdictions. So if you have specific questions, let us know. And I will continue the same thing Jen had, which was a lot of it depends, and every state is a little bit different. So what my goal is with campaign finance and enforcement is really to give you a broad overview of the things companies might be facing in the area of campaign finance, just to give you a taste of some things that you should be thinking about, and also some areas that maybe should get up your spidey sense to let you know it's time to ask some other questions, or perhaps engage your legal team or outside assistance if it's a major issue. So going into the area of campaign finance, I mean, generally campaign finance, what we're talking about is a corporation spending corporate dollars on political committees that can include candidate committees, political action committees, super PACs. There's all different recipients of corporate dollars, or a corporation having a PAC, which means it's taking money through payroll deductions from its employees and directing that money to other political committees. And it can also mean individuals within the company making political contributions as individuals, not reimbursed or directed by the company. So there are a lot of different areas in which campaign finance touches, but really what we're talking about is money from one source to the other, involved in an attempt to influence an election in some manner. So the considerations for campaign finance are, is this permissible? Do I have any limitations? What are my disclosures? And then we're going to touch a little bit on state pay to play, which could be several hours in and of itself. So let us know if you have questions, but we're just going to highlight a little bit that goes on with pay to play right now. So when you're talking about in campaign finance, whether a contribution is permissible, the factors are going to include what is the source and who is the recipient. So the different jurisdictions, some will allow some of these on the list, all of them. It's going to be a mix of the above. So I'm just going to go over a little bit about what that could be. You have direct corporate contributions, where you're talking about taking treasury dollars from the corporation and giving them to a committee. We talked about corporate PACs, personal individual contributions. And there's a different restriction often for contributions if your company does not lobby in a state versus if your company does lobby in a state. The company itself and its individual lobbyists can be subject to different campaign finance regulations because of that lobbying relationship. Other states have gone to a public funding model where candidates are only permitted to take money from a public fund, but if they choose not to, they are subject to an entirely different campaign finance code than if they take public funding. So that's important to remember, because there are certain states that a candidate can elect whether to take public funding or not, and that's going to impact whether a corporation can fund any part of that campaign or not. The other one is a very common, is that companies are allowed to make contributions through their PACs or to restricted accounts, but not to candidates. And again, a PAC in this context is a company that forms an entity that takes payroll deduction usually from its employees, pools that money, and then there's usually a PAC board made up of government affairs people, sometimes C-suite, oftentimes cross-disciplinary across a company, that direct where that money goes. So the people of the company, the employees, put the money in at their own discretion, but do not necessarily choose where that money goes in the end as far as the contribution itself. Many states make the distinction between corporate treasury dollars and PAC dollars because the funding source for one is the corporation, the other is, in the beginning, is actually the employees themselves, regardless of the discretion of how that money gets spent. Many states, again, have some mix of the above. We're talking about limitations, so assuming here that it's permissible, and it's permissible in one of the different forms we just talked about, the considerations are in what amount is that permissible. There are very few states left that allow unlimited political contributions. Nebraska happens to be one of them that comes to mind. You have to disclose it, but you can give in any amount to any candidate as long as the company discloses that, and that can be actual direct corporate dollars. And you have to consider the source again. Is it corporate dollars? Is it lobbyist personal funds? We'll talk that in some states it even matters whether it's the spouse of an employee's funds. So we'll talk a little bit about that. So the source, the timing, just like lobbying where you have ethics restrictions for gifts, there may be timing restrictions for political contributions, the most common one being that political contributions are not permitted during a legislative session or during a special session or during a budget session for somewhat obvious reasons. The other is how that contribution can be delivered. Generally, the rule that we would always advise companies is never make a political contribution in a public building. Never make it, particularly on the floor of a legislature, on any place that's in a public building. There should be a separation between the duties of the public official and the campaigning of the public official. That public official should have two separate channels for that. Doesn't always happen as clearly as it ought, and so companies need to make sure that they are aware of those restrictions. One of the most cautious ways to do it that we advise is that contributions should always be sent by mail with a letter explaining who the contribution is from, how it's intended to be reported, and to go in that somewhat one-off, somewhat impersonal way from the corporation, but allows for a very clear method of delivery and tracking for record keeping and for other purposes. I think we think about campaigns sometimes being very sophisticated. They're taking in a lot of money, but oftentimes it could be an 18-year-old high school volunteer at one end opening up the envelopes and processing contributions into a database. And we need to make sure that that is reported correctly so that contributions from a company don't end up having compliance issues that they don't have to by making sure that they're conveyed in a very clear manner. So the reporting will also vary across jurisdictions. So we're going to go with it's a permissible contribution within the limits. What some states will require is that only the contributor reports. In some states, only the recipient reports. Some states both report. Other states actually require a cross-check between your lobbying report and your campaign finance report. So you're actually reporting political contributions as a lobbyist on your lobbying report so that in public disclosures, people can easily see whether you've made campaign contributions to the same public officials that you're lobbying. So that is kind of that higher level of disclosure that some states are moving to. And some of you have reports based on timing where you may report every 10 days during session or every 24 hours during an election cycle, like when you're, within 24 hours of an election or 48 hours of an election. So there's a lot of variance. And also, again, we talked about transmittal letters. That is a great form of for reporting and both for record keeping. Some examples: Wisconsin prohibits all corporate dollars. They actually it's been 2 years now, that Wisconsin has allowed corporations to give only to the administrative or non-candidate account of a political party or legislative committee. This is a really big deal in Wisconsin because Wisconsin has always been a very clear no state, no corporate dollars, no gifts. So this exception was a big change for Wisconsin. Again, the corporate dollars cannot be spent for candidates. It can only be spent for administrative funds. So you can think of things like a party, a political party. It can pay their rent, their salaries of employees, things of that nature. But that money must be kept in a separate, literally a separate bank account that is only used for administrative fees. Illinois permits corporate contributions to candidates, to PACs, and to parties with dollar limitations that are fairly high. The corporate contribution limits are per election, and for a PAC can be up to $50,000, and it ranges depending on who their contribution is going from, but it ranges from around $11,000 to $50,000 per election that can be given from a corporation. So while there are limitations in Illinois, they are pretty high relative to the rest of the country. We've been talking about state, but it's important to just recognize here that federal candidates may not accept corporate contributions in any amount. So I think there's a misconception after Citizens United many years ago that federal candidates can accept unlimited money from corporations, and actually that's a misinterpretation. That's not what Citizens United said, and that's not what the states adopted afterwards. Federal candidates can accept money from PACs that are organized outside of that candidates committee. And so a company cannot give to candidate X's committee, but they may give to Friends of America or United Americans for X. And that committee cannot be organized by a candidate, cannot be coordinated with a candidate, but that super PAC can be run by a different group of people outside of that candidate and then make contributions to the candidate with those corporate dollars. So there is one more stage in there, and those would be super PACs, as they're commonly referred to, that federal candidates can accept money from, but they may not accept corporate dollars directly to their campaigns. Talking a little bit about pay to play, it's kind of jumping into a little bit of a different area, but it falls under the umbrella of campaign finance. So pay to play laws, they're becoming very common at the state and local level. There are more than half of the states now, I think we're up to almost 30, that have some version of pay to play laws. And more commonly, they're coming in at the local level that are more restrictive than the state laws. And so what pay to play is, it's a different form of campaign finance where it's a restriction or prohibition on political contributions by state or local contractors and bidders. So this one is tied to the doing business with. So if a company is doing business with a particular state agency, or an entity within a state, there can be prohibitions on political contributions based on that doing business with status. And many states now have extended that to even the bidding process. So there can be no political contributions or restricted contributions even during a bid. It used to be that pay to play was primarily for non-competitive contracts where there was no bid, and that's been expanded recently. We'll talk a little bit about some examples, but New Jersey in particular, if your company is doing business in New Jersey and you contract with pretty much any state or local agency in New Jersey, you are subject to fairly strict pay-to-play laws. And I think we can all kind of think back to why New Jersey might be enacting those laws. There is a lot of I guess, momentum in preventing corruption in state and local contracting in New Jersey, and pay-to-play laws are one way that the state's addressing that. So the prohibition in a pay-to-play law can be very expansive. It can include all political contributions by the company, by its PAC, by its officers, directors, by its senior managers, and even spouse and children of certain employees in the company may not make political contributions. And I think when you hear this, many of us think, well, that's a violation of your First Amendment rights for political speech, which has been well established that individuals have a right to political speech, and speech has been interpreted to mean money as well as just verbal. And so no one's challenging this. However, we haven't seen any challenges to these laws, although I think for a lot of people, it's very difficult for people to understand that their spouses are bound by pay-to-play laws because of the actions of their partner, their husband or their wife or their partner's business dealings with the state. There can also be a look-back provision as well as future restrictions. So this is something that a company needs to take into consideration, which is if you're looking to get into state and local contracting, there can actually be a look-back provision of political contributions made to the officials who have decision-making authority over that bid. And so there can actually be a look-back provision in which there's generally a disclosure of all political contributions that may have been made to public officials that have some authority over that bid. And generally there's a future restriction or prohibition as well. So for some jurisdictions, the prohibition on contributions might just be during the bidding period, in which there's obviously a bigger chance of having some kind of intent to influence with those contributions. But many states also say for the period of the contract, there's also a similar restriction. And some even say a period of time after the contract ceases or terminates, there's still a provision that says that even after the contract terminates in Illinois in particular, that company is still prohibited from making contributions even after that bid, because the assumption is that those bids are often, they are often relet on a fairly regular basis, and that company is generally going to stay in that same business of looking to, say, sell particular furniture to the university system. It can be in the agriculture business, providing school lunches, things of that nature. So it's not just maybe construction or other projects we think about when we're talking about bidding, but it often extends to things like contracts with universities or contracts with other state agencies that maybe aren't so obvious when you think about this. For pay-to-play, in particular, the penalties can be very significant. Campaign finance, lobbying, and ethics, absolutely critical to have compliance. The penalties vary, but in pay-to-play, there is a huge risk here because it can include voiding the contract, and it can include imposing restrictions on future contracting with that state. So this is an area where there has to be a lot of training and awareness within companies who contract with the states or with local agencies that have pay-to-play laws, because the risk would be not being able to contract with that entity for a certain period of time, or voiding a current contract, which you can see could obviously be detrimental. So the laws for pay-to-play are sometimes within the campaign finance statutes. Sometimes they're found actually within the state contracting laws or on the bidding documents themselves. So this is an area that when you talk about training and awareness with a company, that it is your government affairs team who needs to be aware of pay-to-play laws within the campaign finance area that they're involved in. Your contracting and procurement teams need to be aware of the political contributions that your government affairs team is directing, and as well as if there's a separate kind of bid team. So this requires a coordination across the company to make sure that the government affairs people or whomever else within the company is responsible for talking with public officials and directing campaign contributions is aware what bids the company is going after, what contracts the company currently has. We even see this now within certain lobbying statutes that require a disclosure of state contracts when you're registering as a lobbyist. So companies that engage in public contracts can consider putting in a pre-approval process for corporate employee political contributions. While this is quite onerous, for a company that has significant state and local contracts, it is often money well spent. And for other companies where this may not be as common to have these kind of contracts, you're talking about thorough training, regular training of the appropriate teams. I'm going to give some pay-to-play examples. again, in the middle. New Jersey, just watch out. You're doing anything in New Jersey right now. The laws are changing multiple times per year in some jurisdictions. So what was true last year, generally just assume in New Jersey that you need to check again. The good thing is in New Jersey is that the New Jersey Election and Ethics Commission answers their phone. They will answer anything that they can do about pay to play. They have an entire section on their public website that goes through all the pay to play rules. It's fairly up to date. So while New Jersey's, they put some really onerous regulations, they are also a very good state to interact with in the sense that they will help you interpret that and make sure you're not running afoul. I think that the state agency responsible for enforcing pay to play right now feels just as inundated as the companies who have to follow those laws. So that's a high point there. Illinois, bring up pay to play. Illinois was one of the first states to really actively engage in this pay to play space as far as regulations. And Illinois requires any company with $50,000 of contracts with the state to register as a business entity, which is step one, completely separate. And the business entity registration includes a listing of contracts. It also includes a listing of corporate officers, which there's a statutory definition of what they include as corporate officers, and the names of their spouses. And that goes on the business entity registration. And then the prohibition actually falls within the campaign finance statute separately that says that corporations registered as business entities can't make certain political contributions to candidates. And generally, it's related to candidates who have authority over that bid, but it is a fairly broad statute. And again, this becomes a little bit maybe just not intuitive, is that the prohibition extends to the personal contributions of corporate officers and their spouses. So not corporate dollars that are directed by someone within the corporation, but actually personal funds, non-reimbursed personal funds that are spent by the officers and their spouses are prohibited. And in Illinois, the way that this is enforced is that business entity registration system, that's electronic, is cross-referenced regularly with the campaign finance system. And so they do actually have a regular enforcement of pay to play because those two databases can be compared to one another and violations can be found fairly quickly. So review your policies and procedures, review your practices, and be audit ready when it comes to pay to play. The bidding process can be very onerous for a company, very time consuming. And so the last thing you want to do is be held up figuring out whether you've given campaign contributions or whether your corporate officers have. And so being ready to understand that these regulations are in place to be able to track this information ahead of time. So following up, train your employees regularly. The laws change fast. They're volatile in the whole area of campaign finance, not just pay to play. And seek outside assistance when necessary, because this is an area, again, where what you did in this 18 election cycle, you may not be able to do in 2020. And people make that assumption oftentimes that these are, the amounts might go up, but the laws don't change. The states actually jump around quite a bit in this area. So one of the things we do to streamline things is we use technology. It's, a common sense thing. We use extranets. We track all information. We do centralized record keeping for our clients. It allows you to do that look back provision, also to be able to compare lobbyist contracts with campaign finance contributions. And so having the centralized record keeping can be critical for compliance. So here we are at the point in which we have some time to take questions. I know Jen and I have gone through quite a bit of information today, so we're happy to do our best to answer things on the fly now. I don't know if there's questions that came in. Okay, so while we wait to see if there are any other questions that come in, we'll kind of talk about some things that are enforcement actions or changes in the law that are happening right now. So one thing to mention, and I'm here, so it becomes pretty easy to talk about, is the city of Chicago is one area. If you're doing business with the city right now, or you're lobbying the city or looking to do business with the city, the Chicago Ethics Commission is really ramping up its regulations and its enforcement right now in a way that's never been seen before. Part of it is that people believe that it's been, the impetus is all of the contracts that are being let with the airport construction has led to things like FOIA requests of the current mayor's personal emails. And those are being used to impose fines on companies who are seen as lobbying on those contracts who didn't register as lobbyists with the state. And those fines are being levied. Some are at least initially being levied in the six figures, and that's for local lobbying alone. And many of those get reduced, and there's a process for that. But the worst thing that can happen here, I think, is that you're looking at publicity your company didn't want or didn't intend in these matters. So when we talk about enforcement actions, a lot of it is about controlling your company's message. If you can be compliant on the front end with lobbying laws and campaign finance and file the proper disclosures, those things are done in a way that fit the state's transparency requirements. And if the news or if Open Secrets or other sources out there on the internet pick up on the campaign finance contributions of a company, they're permissible. There are ways to respond to that. The problem is when those contributions are made and not properly disclosed. What we're seeing right now is a surge in public or watchdog websites now combing through the records from the 2018 election right now. And so just about daily, there are articles right now about illegal campaign contributions that were made in the 2018 election, which could have been something that appears fairly innocuous, where a PAC gave to one committee without understanding maybe its status. But being aware up front is a lot easier than responding to those news articles that relate to contributions that perhaps were refunded or not properly recorded. So the other thing is that it would be remiss if I didn't mention right now that the Democratic National Convention is being held in Milwaukee. And so many of our people today are from Milwaukee or do business in Milwaukee. And so the convention will present its own set of ethics and regulations. The conventions have a completely separate set of rules. So for the convention, if businesses are interested in getting involved in the convention, sponsoring an event, the Wisconsin rules of ethics will not apply to your convention activities, but will apply if Wisconsin officials are invited. And so you have a really interesting overlay at the conventions. So if your company is looking at a sponsorship, there are a lot of prohibitions as to where companies can get involved within a convention. And oftentimes there's literal distance exceptions or regulations. So companies can sponsor events, but they must be outside of kind of the bubble of where they consider the convention being held. And then the second consideration is if you do sponsor events and they are outside of that protected zone of the convention that doesn't allow corporate sponsorship, you still have to be aware of which public officials are being invited to attend, if they're being provided space, if they're being provided food and beverage, or if your company is asked to give an in-kind contribution. So if your product is sought after to be provided at the convention or at an event, those are things in which you'll want to seek some advice and look at current opinions. The convention rules change very regularly. And so in 2018, there were a lot more, or I'm sorry, 2016, there were a lot more restrictions, and we're expecting to see a revision on those rules for 2020. So I think that is one of the pieces. This reminds me of one other thing that I didn't mention, which is the in-kind contribution piece. So if your company or one of your clients is engaged in a business that makes a product that is requested to be used at a fundraiser, inaugural event, that you need to be aware that that's often seen as a political contribution. So we call those in-kind contributions, and those are the ones that are often missed because they don't feel like they involve an exchange of money. And so those are often political contributions. They're often required to be reported either by the company itself, or they can be restricted in the amount. So that is an area that companies are going to need to be aware of, both for the convention and generally as an area that gets missed in the campaign finance world. I'm going to stop and see if anybody's got outside questions at this point. Okay, so I think we'll just go through a few more things. The other area that we just touched on that has passed a little bit, but for those states that run 2019 elections, is inaugural contributions. So inaugural contributions often fall under campaign finance statutes as well. And other states pull inauguration events completely out as a celebration that's not political in nature because the election is over. So those are important things when you are considering, again, either giving money to an inaugural event or making in-kind contributions, such as providing food or beverage or even space for an inaugural event. You've got to think about campaign finance laws. You've got to think about reporting, as well as whether that counts against any contribution limits for the most recent election or a future election. And similar to inaugural contributions, there are other exceptions in states that are considered part of that celebratory piece, which, for example, in Texas would include Governor for a Day, where the governor solicits money from corporations to sponsor an event where they have people come in and serve as governor for a day, as kind of a celebration of government. And there are actually statutes that make exceptions that those are not campaign contributions, but it's really important that a company understands how that contribution has to be conveyed, that it's not conveyed to the actual political figure who's asking for that money, but it's conveyed to a separate account. So again, that goes back to good record keeping and transmittal letters. So those are the types of special events that are exceptions. You think of inaugurations and those other special events outside of that. And the other category I think we have just a few minutes to look at is what in the statutes and we refer to as behested payments, which also fall within campaign finance. And that's simply a public official asking for a contribution to another source. So, or to another recipient. Generally, that is going to be a political figure requesting a contribution to a nonprofit or a scholarship fund. And there are many restrictions on that within the states and at the federal level about whether a company can contribute to, it includes things like a presidential library fund, but also more commonly, legislators and retired legislators will often have scholarship funds or hold charitable events. And so companies need to be aware that that can be seen as a political contribution, or it needs to be made in a certain manner to make sure that it's going directly to a 501c3 without passing through the campaign in any manner. And it can also, there are different rules if it's going to a 501c4, but really clearly understanding whether this is a charitable event where the funds are going through the campaign, are the funds going directly to the 501c3. There's a second set of regulations here, which is whether that is even ethical for certain officials to ask people to make contributions to charities that they support, seen as, might be too strong of a word, but kind of an indirect coercion of, you know, you need to support this charity, and person feels obliged to do that because this is a political figure in which they have other contact with. So making sure that you think about the ethical considerations. This should not limit a company's philanthropic giving. It just needs to be reviewed to make sure that any contributions to nonprofits that involve an ask by a public official are made appropriately. The third thing to consider when a company is asked to give philanthropically and it has something to do with a public figure is, so you're thinking about whether it can be made, how it needs to be made, whether it needs to be reported and disclosed on some kind of filing that the company has to make. And so this can include a lobbying filing. So if a company is a lobbyist in a particular state and lobbies in front of the official or the agency that that official sits with, that can be seen as a lobbying expense as well. So while it might be permissible, it needs to be reportable in a manner that is consistent with campaign finance laws, ethics laws, and lobbying laws. So this is an area where it all kind of intersects. So I think where this all comes down to is that If your company is involved in any political activity, it can include lobbying, campaign finance, entertaining legislators. All of these things intersect and are important to have training for your legal team, your government affairs team, your C-suite, as well as on a bigger, broader basis, including it in your code of conduct so people understand at all levels, including sales, whether it's appropriate to make contributions or take an official out to lunch. And so I think with that, I think we'll wrap up. But if you have any questions, Jen and I are available. Let us know. And thank you guys for your time.